Warm welcome to this week's edition of Yilungelo, Lakho, it's your right. Having a written will may seem easier than winding up a deceased estate. Imagining a glitch-free distribution of assets to surviving beneficiaries may just be a fantasy, as the process is often fraught with obstacles. Bekunene kwaba ke lifa ngekwetifiso temufi akusilula. Ngalesinye isikhathi ke kwaba lifa akuhambi ngesifo semufi. Lokho ke kubanga inkinga letinengi, kubange ingxabano nekungafisisani. To talk to us more about the delays, what could possibly go wrong, and of course the reasons in the distributions of a deceased estates, let's now welcome Angelique Krugel from the Fiduciary Institute of Southern Africa, Smugelena Shagazwan, and Lubwege Standard Bank. Very good afternoon to you too. Thank you so much for joining us. Welcome.
Thank you very much.
I'm going to start with you, Angelique. Let's talk about winding up a deceased estate. We've heard this term so many times. What is it, and what does it entail?
Well, the executor is normally appointed by the Master of the High Court, so it could either be in terms of a will, or it can be in terms of the law of interstate succession where there's no will. So the executor needs to see that he takes control of the deceased assets, make sure that all the claims are paid, and then whatever's left, then it will be distributed to the beneficiaries. But in a nutshell, this seems very short, quick process, but it's not, because there's a long legal process to follow, and a lot of players in the process that one has to liaise with, so it becomes quite a lengthy process.
When you spoke of testate and intestate, it's a different dimension to this conversation, because there's a difference between testate and intestate. Maybe if you could just shed more light on the differences between the two? That's
correct. When you have got a will, you obviously nominate an executor who will immediately be appointed in the event of death. If you die without a will, there's no executor that has been appointed, which sometimes mean that a family member has to be appointed as an executor, or they can approach a professional. But very often the family members don't agree who should be appointed. And that could be one of the reasons why it also takes much longer to have an executor appointed. Because the executor is the person that steps into the shoes of the deceased and need to make sure that the assets are dealt with and the whole process is being properly dealt with accordingly.
Let me also bring in Shaga into this conversation. Maybe now, what really makes it makes the process so long, and what are some of the logistics involved?
In fact, irrespective or irregardless of what state, the process can be very long. Processing anything from 12 months, 24 months, or even 5 years. And what causes that in most cases, you'd find the estate has got what we call a cash shortfall. Lomdo shonile ushone anezkwelete eziningi and azanga provide mhlambe life cover or enze izaba zokuthi uma seshonile, what will happen to the debts? And so it becomes very difficult and a long process to wind up in a state. So one could be a cash shortfall, but the other one may also be kuna assets evaluate, and some assets you can evaluate at a certain point of the year. So for example, if the business rights somewhere, own shares somewhere, kutatis to evaluate shares in a company, if you had shares in a company, or kunama properties amaningi, sometimes those properties will all have to be sold first, realize the value, imali ingene estate, and then you can start doing your liquidation and distribution account. So there are many reasons, but the ones that worry us and the core ones, there's normally what we call a cash shortfall on the estate, and that's what we want to warn people about today.
So what are the implications of this cash shortfall? Because I would imagine that the debts far outweigh the estate, or whatever assets that are there in the estate.
Absolutely. The biggest implication is that you can end up where you had property, for example, that was paid up. You want to secure your family and make sure one day when you are no more, they are secured, they are taken care of. A cash shortfall, there may be instances where we have to sell property. Literally get your family out to sell the property to cover the cash shortfall in an estate. And what causes these shortfalls, it's the debts, it's the expenses that have to be paid from the estate. Let me give you one such example, and I think Angelique touched on it a moment ago. There's this thing we call estate duty.
Yes.
Where it takes no more feel. And
Sure.
Estate duty can be anything from 25 to 30% in this country, or 20 to 25%, depending on the size of the estate.
Okay.
So, ukuze ukhokhele uSARS leyo estate duty, if unganayo liquid cash or unganayo liquidity, what we call liquidity somewhere, ukuthi ukhokhele uSARS, we may end up having to sell, property, or realize or sell some of the assets to be able to pay for the estate.
So in the instance, and I want to rope both of you in the instance where even after selling, this estate is still in the negative, does that mean that the beneficiaries of that particular estate, end up owing the estate?
I think it's important to differentiate between insolvent estate and a cash shortfall, because normally you would have assets and there would be no cash, but the net value is there's still a balance. But in a situation where there's more liabilities than assets, then it becomes an insolvent estate. So a beneficiary does not really inherit any debt. They're not responsible for the debt unless somebody assigns surety for it, but they're normally not responsible. They'll only get the balance after all the costs have been paid. But the detriment to the beneficiaries would be, often we have a situation where there's, for instance, a husband and a wife or a partner living together, and they think there's enough cash, and when the second person passes or one of the people pass away, they can't apply for a bond because they don't qualify to take over the bond, which means that the bond has to be paid, the bank needs to be paid, so then there's no option but to sell the fixed property, which is obviously not what the testator most probably would have liked. So if I go back in terms of one of the delays, planning is extremely important. I think if people just plan, they would know all these matters and they can plan accordingly. It's critical in the process.
And Simphiwe, maybe if I can add, we talk about having assets. So having assets in an estate is not the end all and be all. Assets. What we're trying to bring across, you do need liquidity in an estate to avoid your estate having a cash shortfall. That means that's going to protect your house, all the key assets that you have in the estate, so that they are not touched and don't have to be sold to realize cash to be able to pay for other things that needs to be paid. So it's important to have assets in an estate, but some of those assets have to be easily liquidated so that you can be able to fund many things like estate duty, executors' fees, etc., etc.
So who bears the responsibility and the honors of winding up the estate and tracing some of the assets that the deceased might have had?
That becomes the role of the executor.
Okay.
So the executor gets appointed exactly for that reason, is to understand what assets exist in the estate, what liabilities are there, and then of course start doing the paperwork.
Okay.
And that's why there are two. There's a legal aspect to it, but there's also the administrative part to it.
Yes.
And the administrative part talks to exactly that. How you fund assets, how you fund liabilities, so that, because what can also happen is that once the estate is far down the line in terms of being winded up, it can be a problem when then suddenly you find out there's a big debt or there's a big asset which was not included when in the beginning, when you declared to SARS, because when you go to SARS to pay for estate duty, you must have declared all the assets, so that when SARS charges a particular, when they charge the tax, it's on the totality of the assets.
Right, right. Yeah. And it's quite interesting that you say that, because some other people may register their assets in somebody else's name, so that whenever the debtors come for the estate or knock on the estate's door, then they find nothing. How is that how are they able to trace it?
Yeah.
Is there a way of tracing it?
I think it's easier nowadays because most transactions are electronic, and one is able on systems to trace certain information. And if they start disposing of assets, there's donation tax. So one needs to, if you suspect that assets have been transferred, you can always go back on the audit trail. But I think mostly people are just unaware of all the assets that form part of their estate. and sometimes the assets that do not form part of the estate. That's what I often find, is that people don't understand that a pension fund is different to an estate. Those kind of scenarios which happen, but you can find most of the assets via systems.
Right.
And that's why the will comes into play.
Indeed, indeed.
If you draw a will, you will make sure that you record all your assets of consequence.
Okay.
And that also brings Simpiwe. That's why we then talk about estate planning.
Yes.
Uma estate planning yakho kahle, you can actually make sure that you account for all your assets.
Okay, I'm going to ask you to hold your thought, because now you're raising a different dimension that I want us to tackle in the next segment. You know, when it comes to trust, when it comes to will, when it comes to pension funds, because it's a different dimension to this conversation altogether. But let's leave it for now. Mbukele ke sithi shile ngasetitolo uhlala kanye nathi ungasanyakati. Leli lungelo lakho. Siyabuya khona manje. Sikwamukela futhi ngibukela icingo tethu setivuliwe ukuthi ke nawe ungaba ingcenye yenkulumo yethu namhla ungashare icingo khona manje la e-studio ku 0117140671 noma ke 0117140672. Ungasithumela futhi ne-WhatsApp ku 0608449857. You can also email your thoughts to consumer@sabc.co.za. Uphindze usithinze futhi etinkundleni tethu tekuxhumana kubo Facebook. Namhla ke bekunene, if you just joined us, sikhuluma ke ngema wills or deceased estate noma ke kwaba emafa alabo la sebasishiyile, also known as winding up an estate. What is it that you need to know? What is it that you need to take into consideration before drafting a will? And a little later on, sawukhuluma ngomcoka bekudrafta i-will nokuthi ke yini okumele uthi ukuze kuthi udrafte i-will, ukuthi ungatendela yini noma ungacela ke ummeli noma ke libhange batendele ukuthi ke what does it really take for a will to be valid? And it's netini intethu ke namhla, and I just want us to extend the conversation further into, you know, whether the presence of a valid will is sufficient to ensuring that everything goes according to plan. Right?
Yeah, so Simpiwe, the presence of a will is actually a great starting point. I think in South Africa we're very lucky as the citizens of our country that the laws actually allow us to can draft our own will. So you can draft your own will or you can use professionals. But we are here to actually advise Ababugelo Luguti. It's always advisable, if you can, to use, and to draft a will is not very expensive. We always encourage that people use professionals to draft your will, but you can draft it yourself.
Yeah.
You can use attorneys, banks do this service. In fact, if it's a what we call a less complex will, it becomes, some banks draft it for free if it's a less complex will, and some institutions. You can use accountants, those who've got accountants. So it's always advisable to use professional people, because there are some legal complexities about drafting a will that you might not take into account, which might render your will actually invalid.
What are those complexities, Angelique, if you could just take us through
Yeah,
it?
I would always recommend, because, you know, although you've got many accountants and you've got financial planners and you've got lawyers, you've got a lot of people that can draft it. The fact is that not everybody specializes in fiduciary, and it's a very specialized field. We often, obviously being part of the Fiduciary Institute of Southern Africa, always say rather could deal with one of the FPSAs, meaning somebody that's got professional experience and also subscribe to a code of ethic, so that they are able to do their job. Now, drafting the will normally looks very easy because there's a couple of clauses, but what is extremely important is to look at the underlying assets, and that's when it comes to the execution of the will that it really, you know, shows whether it was a well-drafted will or not. Because, I mean, you could have a situation where somebody, I've now, for instance, seen somebody bequeath the entire estate to a family trust. But when we looked at the family trust, we saw, oh no, the family trust has to dissolve in the event of death. So, you know, those are practical implications that one deals with. Or, you know, a person drafts his own will and he says, my pension fund needs to be paid to son A and my house goes to my wife. But ultimately, the pension fund doesn't form part of your estate, meaning that his wishes are not going to be abided by. So it's really important to look at all the underlying assets to understand what laws are applicable to that specific assets, and then you can see whether your will would provide for your wishes in the event of your death. Also, your living annuities. As long as you understand all the different assets, then you can draft the will according to how the assets are structured.
Yes, yes. And then when it comes to, you know, the distinction between a will and a trust and a pension fund, What is it that we need to know? And what are some of the differences between the three? And are they governed the same or governed differently by the pension laws and some of the wills laws in the country?
So I'll tackle the wills and the trust, and then I'll talk a bit about pension funds, and then Angelique will also come in. So it's important to understand that a will and a trust is not the same thing. But a will can give rise to a particular type of a trust, what we call a testamentary trust. A testamentary trust is a trust that is created because umuntu wenze i-will, wayithi uma eseshona wabhala ku-will yakhe ukuthi onke ama-assets wami or ama-assets athile must be transferred to a trust. And ama-beneficiaries waleyo trust kuzoba usibanibani nosibanibani nosibanibani.
Look, Shotsuke, one cannot override the other.
Absolutely. It can give rise to the other, but cannot override the other. But what
so can it work independently? Like i-trust isebenza yodwa, i-will isebenza yodwa, ne pension fund?
Absolutely.
Okay.
It can. So what is important is that there are different types of trusts. You get what we call a testamentary trust, which is what I've just spoken about, which comes into effect upon the will coming to the estate coming into being. We also have what we call settlement trusts. Settlement trusts are payouts, mostly funds which are being claimed, for example, road accident funds, etc. Those funds can be paid to a trust, and normally they're paid into a trust. So those are what we call settlement trusts. And then you've got what we call inter vivos trust, which is a living trust. Okay. So I can form a trust in Gipila and have beneficiaries and people, and it can run parallel with the will. Okay. But it can be a trust where certain properties, certain assets are actually in the name of the trust as opposed to be in my personal name. Okay. Again, is to make sure, upon my death, as an example, those assets are intact because they're in the name of the trust, not in the personal name. So that's the difference between the will and the trust. A will largely is to talk about what happens to my assets, what are my wishes about my assets upon my death.
Got you.
And then you can talk.
Maybe, Angelique, before you weigh in on what he just said, a pension fund is governed by pension laws in the country.
That's correct.
And then a will and a will and a trust, which laws govern those? And if I have a pension fund and I don't have kids, and then later on I do have kids and then I die without updating the pension fund, would the pension laws apply, or will the other laws apply in this particular instance?
Pension Fund Act will apply, and normally there's trustees that will determine who were actually dependent. So even though people are encouraged to put nominated beneficiaries on their pension fund, it's not necessarily that they are going to benefit, because often what happened in the event of death, the trustees would approach the executor to ask for a copy of the will. They'll also ask for a copy of the liquidation and distribution account, which is a name for assets and liabilities, just to determine who are going to benefit out of the estate, because they take that into account to see what payments they are going to make to the beneficiaries. And often there's people that family members didn't even know that were dependent that also come, to the forefront.
All right. Okay. Let's now take our first caller. Sina Kenny ulapha ke Soweto. Sakumukele ehlelweni sawubona.
Sawubona speech. Speaking nenkinga lana mina umama wabhalisa ile will 1979 and i-will yanyamalala e-ofisini. But manje angazi ukuthi ngingayitrace kuphi ukuthi ngize ngiyithole again.
Kuliphi office? Inyamalele kuliphi office?
Inyamalele lapho esibhadala khona irent e-ofisini eJabulani.
Manike, in whose position was it?
Ibifakwe ofisini la sibhadala khona irent. Angithi ibekwa endaweni yezindlu.
Okay.
Yeah, yanyamalala lapho.
Yeah, that's a very interesting question. Thank you so much for your call, Kenneth, and we'll definitely, tackle that in just a moment. That was Kenneth in Soweto, and I would love both of you to respond to this particular query. Please do join us after this break. Leli, Yilungelo Lakho. Well, Welcome back, everybody. Kumbula those magic numbers are on the screens right now. There you go. 011-714-0671 and 011-714-0672. You can also send us a WhatsApp to 060-844-9857. Nomage usithumele email ku consumer@sabc.co.za, or you can even like our Facebook page. Earlier on, we had a caller, Kenny from Soweto. Basically, in a nutshell, he was saying that his mom had a will in 1979. She unfortunately passed away, but the will was kept at the, I suppose, the municipality offices, and it disappeared without trace. So what really happens in that particular instance?
Well, if there's no will that can be found, the estate will be administered in terms of the law interstate succession. Then there's specific people that will benefit. If his mother was married, then the surviving spouse would obviously get the entire estate. If she was married and also had children, then it would be the spouse and the children, and they divide the number of children and the spouse, with the spouse having the first 250,000 would always go into the spouse.
So who's the direct beneficiary? And in terms of an interstate, distribution, how far back in terms of the generations does it cover?
There's a few lines that you go. So it will all go to the surviving spouse if there's no children.
Yes.
If there's children and a spouse, it will be divided between the spouse and also the children, and they will each get a child share, that calls it. Right. But also with the proviso that the surviving spouse will always get the first 250,000 rand. So if the estate's only worth 200 or less than 250, the surviving spouse will receive the full 250,000. So, and then if, say for instance, there were 4 children and 1 child has passed away, that child's share will then be divided between his or her children if he or she had any children. So it all goes to the first layer always, and then after that, if a person passed away, it will go down.
Okay. Your thoughts?
Yeah, so what is also important, Simpu, is that, if a person can prove that they, for example, were taken care of by the person who passed away, and they had an allowance or someone into your immediate family, your mother, and so on, we also consider that. But I think simply this again always necessitate the need to have, the will, because one of the things that we were just talking about earlier is the fact that it will not only caters for the assets, but it also talks to the guardianship of your children. People pass away by nabantwana, and you want to make sure that you've left the guardianship or umsebenzi wokunakekela abantwana bakho to the right person, because the will does stipulate that, and it gets done according to your will. That's why it's a will. It's done according to your will. If you don't have a will, there is no way. Imagine you've got 2, 3 children. There's no way you stipulate ukuthi abantwana bami, I want them to be looked after by so and so, and that is catered for in the will.
Manje ke nabe kunebantwana labaqhamuka from other mothers, from different mothers. Bona ke baprova kanjani ukuthi I'm the beneficiary and the deceased is actually my father or my mother or my parent?
There's always means to prove that. I mean, you can't have anybody just coming up and saying, this is my father who passed away. In
this particular instance, the owner of the estate, and there's no DNA to be
there are many ways you can prove that medically. There are many ways to even mention. So it may be DNA, but of different sort. It may be if there is, for example, family links. If you look at the family tree, if it can be proven that this indeed was the father, or there was proof that the father took care of this child while they were still alive, or the mother, that can still be proof enough to say that this was the family member.
Okay, so resemblance, you can't say, he looks like my dad. No, you are the one.
I can add to what he says. The Children's Act specifically says that you have to nominate and appoint a guardian.
Right.
Correct.
So there's actually an obligation on a parent to do it in their will.
All right. Let's take our next caller. Sinamampiri ulapha ke Thokoza. Sakumodwe sabona.
Yebo baba ninjani?
Siyaphila kunjani mama?
Ngiyaphila mntanami.
Khuluma nathi mama.
Nithi mina ngathatha iwili lapha eMall of the South Alberton ma Standard Bank manje kusho ukuthi kunabantwana abayibhengi lo mfana uyazathuki manje ushonile manje ngizwa bathi iwili mawushonile ithatha imali eyileyo manje bengicabanga ukuthi ngisuse manje futhi okunye abantu abangithendela ama-message bangifonela ukuthi fani yobhadala manje mina lesikhathi ngiyithatha ngizange bangitshele lokho.
Mane ngicela ukuvisisa kahle la uthi wathatha i-will and then one of the beneficiaries lo ngumntwana wakho washona.
Yeah, umntwana washona sasithathiswa yilokho ngoba bekumntwana osewutiliyane yabona ukuthi angabunga lababayi manje sekusele laba abayi-2.
Okay, all right mama. Ngenhlanhla lenhle ke ukhona ke i-representative of Standard Bank utasichazela kabanti ke kulelo hlangothi. Thank you so much for your call. Siyabonga kakhulu ukusishayela mama. Ngiyathemba kumvile ke mama ukuthi
ngimvile mama Simphiwe ngizozama ukuphendula umbuzo wakhe ngalendlela engimuzwe ngayo. So kunezindlela ezimbili ezenzakalayo kuloko. Kungenzeka ukuthi uze e-Standard Bank noma ngabe yipi bank ubacela ukuthi ngicela nje ningidraftele i-will kuphela. Ngizozikhethela ukuthi ubani ozoba i-executor but nje engicela kunini ukuthi ningidraftele i-will nje kuphela. So that's number 1. Okwesibili kungenzeka usicela ukuthi sikudraftele i-will uphinde ucela ukuthi futhi i-Standard Bank ibe i-executor ngamagama i-Standard Bank ibe umabeli mafa. So there's 2 ways. So okokuqala kuzofanele understand ukuthi umama akuyikuphi ukuphi acelile ukuthi adraftele i-will kuphela uzozikhethela umahluleli mafa or uzo draftele i-will appoint in Standard Bank as the executor. Uma ngabe understandile which of the 2 options umama zikhethile, we then have to go and check ukuthi yini ofanele ishintshe uma sekushona umntwana wakhe. Ngifuna ukucorrecta Nkosi yami Simphiwe into eziningi ezihluphayo lezi akusiqiniso ukuthi ukwenza i-will into edurayo. I mean I can give you an example. For example, we do wills for free for certain segments at Standard Bank. We've got a segment we call a middle market segment. Uma uvule achiever account uthola i-will for free. Uma une-account to a private banking account uthola i-will for free. So akusiqiniso ukuthi ukwenza i-will kuyadura and iloko sizele ukuthi sikulungise abantwini bakithi ukuthi siyanikhuthaza Simphiwe over 70% of South Africans die interstate, which means bafa bengenayo i-will.
Manje ke mampiri yena uthi akhona ama-course lekuthiwa ke kumele awabhadale ngimaphi la ma-course angena kanjani?
You see, I'll have to understand ukuthi is it because of indodana yakhe leshonile or you know safe in some instances what we call a safe custody fee, but again we look at different clients and lento decision oyithatha uma uthatha i-will yakho ukuthi did you say I agree to pay X, because there are costs when they will. Some banks and some institutions charge for a will, drafter, and then they charge for safe custody fee. In other words, ukuthi sikugcinele will sizokcharge imali ethile every month. But that's not across the board. Again, it differs from institution to institution.
Okay.
Yeah.
All right. Asishiye lapho ke mbukeli sisekeshelela ngasetitolo. Siyachuba futhi nenzaba yethu yema wills in just a moment. Leli Yilungelo lakho ungasanyakati. Sakumola futhi embukele tincingo tethu solo ke tivuliwe ukuthi nawe ungaba ingcenye yenkulumo yethu namhla ungashaya icingo khona manje. The numbers are on your screens 0117140671 and 0117140672. These are participation lines. Ungashaya icingo khona manje la e-studio kubuta umbuto noma ke kuvakalisa umbono wakho. Ungasithinza futhi na ku WhatsApp ku 060-844-9857. You can also email your thoughts, your views and even your questions to consumer@sabc.co.za or catch us on our Facebook page. We've got a third caller. Sina Spiwe ulapha ke David Johnson. Sakumola ehlelweni sawubona.
Sawubona bhuti kunjani?
Siyaphila kunjani baba?
Ngiyaphila ngicela inkinga. Ngaya e-Standard Bank ngifuna ukwazi ngendaba ye-trust fund yakamama. Mama washona ngo-2013. So mangifika e-Standard Bank bathi kimi no umama ka-appear kuma-records wabo.
Mane ngicela uva kahle, your line is not clear. Uthi umama bekane trust e-Standard Bank angisho?
No? Yes.
Okay. And when you were the beneficiary?
Yes.
Okay.
And then one thing Standard Bank, I think 3 months ago, they said that umama akasa appear kuma records wabo Standard Bank.
Okay.
And then man referela futhi kwenye ibranch but Liberty Life.
Sure.
And then Liberty Life manga fonela, bang fonela back, but give information kama mama basenayo bacela ama documents wakhe wase Liberty Life.
Okay.
Ofisi anginawo angisenawo mina ama document because bengase aware zonke lezi zinto lezi. Ngicela ukuzithola I think last year ukuthi kwenzakala. Yes. So ngicela ukubuza ukuthi ikhona enye indlela maybe engayithola or engayizwa engangisiza mina.
Okay, Spiwe, siyabonga kakhulu ukushayela sicela uchubeke ubukele ilungelo lakho on SABC 1. Ukhona ke lilunga le Standard Bank litakuchazela kulo mbuto loyo. Well, just for context, he's basically saying that his mom had a will but she passed away, and that when she went to the financial institution that holds the will, and he was told that her mom's name does not appear. But I'm going to ask you ukuthi umphendule kulolu hlangothi.
Absolutely. Putwami, Spiwe, I think the best advice I can give you, Uguti Wazagiti, let's meet with you and talk to you. It depends on where you are located. I'm going to ask that they give us your contact details. You may not even need to physically come and see us, but we can reach out to you and then be able to assist you. So what I would encourage, it's possible. It depends on what we are WEP branch. You know, we're a bank that does many things. Okay. In some areas where you may go, your name might not appear.
But generally
it's very strange that it's very strange. The other thing
have you had instances?
No,
like this
it's quite confusing because uputukulmang Liberty Life policy. Whereas a will normally gets drafted by our entity called Standard Trust Limited. But it is possible that his mother's will was drafted by Liberty. It's highly likely. So I'd recommend...
Liberty, they've referred him back to Standard Bank.
It's possible, yeah. So I think the best might be Tolama details kaputi and unpack and understand exactly what actually transpired. Okay. Because it's difficult without proper information.
Right.
Yeah.
Let's now talk about, let's get to the bolts and the nuts of what really makes a will valid. Can I take a blank A4 paper and list all my assets and then list my beneficiaries? Of course, there has to be a signature and 2 witnesses. Can that make my will valid?
It could be, provided you are 16 years old if you write the will. And you also need to make sure that your witnesses, there are 2 witnesses that sign, and they must be older than 14 years. And we normally say that they shouldn't be benefiting from your will because otherwise they will be not receiving anything in terms of the will.
So I could get anyone as a witness,
yes,
not necessarily a relative? No,
not at all. We prefer actually independent person that's not going to benefit in any way from your will. So then you can draft your will. The only thing is that it may be problematic when you execute the will, because if you don't bring in all the clauses, it could be very difficult to administer that estate in terms of that will. So it may be valid, but very difficult to execute.
But what clauses could it be? Because I know what I'm talking about. I know what my assets are, and I know who my beneficiaries are. Okay,
for instance, if I bequeath my farm property to my children, it seems very executable, but there's limitations. You can't transfer agricultural land to more than one person without actually getting consent from the minister. And that could take months before you can do that. So what we normally will bring in is clauses in the will to say that in the event that there are assets that you can't transfer, that you can set up a trust to hold it, or you can set up a company, or you can enter into a redistribution agreement. So often if the will doesn't provide it, you can still enter into a redistribution, but not everybody agrees. And I think that's when it is, especially when you've lost a loved one, people are sometimes more emotional, and then you take a long time to agree to move forward. So that's definitely one of the things to bring in. And also for minor children, I mean, you can also say that I bequeath to my 4 children, but what happens if you don't update that will and some of your children have passed on? Who are going to benefit then? Then you've got minor children, which means that there's no testamentary trust, which then it goes into the Guardians Fund. And there's nothing wrong with the Guardians Fund, but it is difficult to access the funds there on a monthly basis. Whereas if you've got a testamentary trust for your minor children, the trustees would look after those assets. They would on a monthly basis pay the school, pay funds for the medical aid, do all of those things that the parents would have done financially for the child. So the trustees fulfill that financial role, and they make sure that the assets are protected and that the well-being of the child is taken care of.
Can it only be reduced to one format? In short, in as much as what you're talking about is, the black and white will, which is on a paper, on a piece of paper, or in whatever document, but can it also be electronic? Can I shoot a video message or a video recording to make that will valid?
Video, not at this stage. It's not valid in South Africa yet. We see it on the movies, and it's good.
Okay.
So when people do that, it's more kind of express their wishes, or it's a message to the family.
Correct.
But it's not a valid will. You still have to, and that's why during lockdown we were really destitute, because that's one of the documents that still has to be physically signed.
Right.
So that's why it was very difficult. We couldn't actually sign wills during the time because people couldn't get close to one another to get it signed.
Simply, that is such an important point. A will has to be drafted physically.
Okay.
That's one of the things that...
On a paper, black and white.
On a paper,
okay.
That's what the law of our country requires. And it's actually very helpful during difficult times. That's why, you can't get around that one. You can't record it, it's got to be physically drafted on a piece of paper. And there's something very important that Angelique has raised. Ogoti, having trustees manage your Guardians Fund is so important, because
yes.
trustees can also invest the funds in the trust in areas where they can get competitive rates, get good returns for your children, so that your children tap into those funds for a longer period of time. If you don't have a will, you can have a guardian appointed, but that guardian may not necessarily have the expertise to can invest your children's funds in the right instruments for them to get the right returns in a long period of time. And that's very important. That's why we say, have a will, have a will, have a will. Kubalulekile.
So an electronic signature? Like if I draft the will on a computer and then I electronically sign it?
That is allowed.
That's still allowed.
That
Okay.
is allowed.
Well, asasel carefully reflecting on the aslane futhi sibuya etimagete. Leli Yilungelo lakho siyabona kwa manje. Welcome back Sakuba futhi nenzaba yethu ke kusasekunengana ke lesingaqosha ke lesiqephu sethu sekugcina kepha ke before we do that, let's take our very last caller sinamahlakala ulapha ke eMabopane. Very good afternoon to you. Welcome. Matlakala in Mabopane, good afternoon.
Hello. Hello.
Good afternoon, ma'am. Kunjani? Khuluma nathi ma'am.
Ngiyabulisa la.
Khuluma nathi ma'am, what's on your mind?
Hello, mina ngikhuluma noMatakala wasina ukuthi
Welcome.
ubaba ushonile angayenzanga iwili. Washada umama, wasithola endlini umama. So manje ubaba washona asakwazi ngene endlini. Manje ngifuna ukwazi ukuthi thina abantwana bababa singena kanjani ngapho ngicela isizo ngoba asazi ngoba asakwazi ngene endlini.
Manike, your line is not the best. Uthi ke baba washona and then mama kicked you out of the house.
Usitoshile ubaba wagula basitoshe endlini. So umama uthole sihlala endlini, ubaba wamshada wangena endlini. So ubaba
Okay, so basically umama is your stepmom, right? Okay. Okay, I think we got the gist of your question. Thank you so much for your call. So she's basically saying that her dad died without a will. And then I suppose the stepmom kicked them out of the house. What really happens in that particular instance? Maybe I would love both of you to respond to that.
So my comment would be that becomes more of a legal matter. It becomes more of a kind of like a legal matter. It's not really something that we can cover from a disease perspective. But as a child,
an interstate rule come in?
I was about to. So she does have certain rights, and she has to basically make sure that she activates her rights. So the sad thing is that her dad again, passed away interstate.
Yeah.
Did not specify who gets the house, who gets whatever. But
so
as
how
a
does
child,
she activate her rights?
as a child, it will have to be approached from a criminal perspective. She has to approach the police and deal it with the law enforcement agencies.
We didn't touch on that though, the criminal element of an interstate estate.
I think what is explained happens very, very often.
Very often.
Because now the stepmother is inheriting together with the children.
Yeah.
And sometimes there's conflict situations. So it will be in terms of the law of interstate succession. But what could also come to play is that the surviving spouse could claim maintenance from the estate, which means that she could wipe out the entire estate, meaning that there won't be any benefit for the children, especially if the children are major. You know, they were not dependent on the deceased. So there's a lot of factors to take into account. But yeah, these are definitely conflict situations that the executor has to deal with. And once again, we can say that executors, you know, anybody can almost be appointed as an executor.
Okay. Maybe let's be direct now. What should she do? Should she go straight to the master's office and explain the whole situation to kickstart the whole, estate distribution?
The first thing would be for an executor to be appointed. That would be the first thing, and then the executor would need to deal with this. So if there's no will, then amongst them somebody needs to be appointed. There's various documents to be completed and lodged with the Master of the High Court, and the moment that the executor is appointed, he would be able to deal with the situation.
The executor's job is to collect all the assets and the liabilities. Could be that there is a house, but there could also be liabilities that, for example, the surviving spouse is having to deal with. And that also, to some extent, can entitle her to, like to the point that was made earlier, there could also be a claim to the estate because there's, there's younger children that have to be looked after. Right. So the advice is always deal with the executor. She must understand who's the executor and engage that person and state her claim to the estate.
All right. In as much as Mrs. Kulmile throughout the show, will, anybody can draft a will as long as they are of the legal age. Yeah. You can do the will on your own. But you did advise earlier on, it's more advisable to ask an expert, a legal practitioner, an attorney, or even a financial institution to draft a will for you. So what could possibly go wrong if an attorney or a bank, drafts a will for me? Because we've heard so many instances of where will being disputed.
Sure, there's a lot that could go wrong. So first and foremost, these professionals that we've spoken about, banks, attorneys, accountants, would generally draft the will properly because they understand the law and they understand what governs, the laws that governs the will, pension fund act, etc., etc. But things do go wrong. And in most cases, it is important to highlight the fact that even if your will is drafted incorrectly, but when it's drafted by a professional, you can have a recourse, as opposed to, again, back to what we said, where you do your own thing and there's conflicting issues and you have absolutely no recourse. I don't know if you'd want to add anything.
Yeah, you're absolutely spot on. You have to have somebody that understands and have experience in the process, because the person that's drafting the will with no experience, they don't know what can go wrong. So they don't know what clauses to bring in. But if you're a professional and you've dealt with will drafting, estate administration, you know what to look out for. You actually ask all the questions, and there's certain information would give you a red light and say, I need to prepare for this, I need to add this, I need to bring this in, and they would have a discussion. One thing, for instance, a closed corporation, and a lot of people still have closed corporations, and that you have to have the consent of the co-member in order to transfer out of the estate. So you have to go to court to get consent if the co-owner doesn't give you consent to transfer. Okay. So those are really a lot of things that can just prolong the administration process. It can add all the costs because it's high court applications. So there's a lot of matters that if you just draft your will, you don't know what your situation is or what it could be, and then not cater for it in your will.
All right, unfortunately we're out of time, but when it comes to marriage, if we are married in community of property, does that play an influence to how the will is distributed in the event that we divorce?
Absolutely. That's why, firstly, I have to highlight that for any big life events that take place in your life, you have to think about your will. You've got to update your will. If a child is born, you've got to update your will. If you get married, you've got to update your will. Being married in community of property comes with certain inherent legal ramifications that you cannot change. Meaning, if we're married in community of property, each spouse is entitled to 50% of the estate, of your estate. The spouse is, your spouse you married to is entitled to 50% of what you own.
So even if
and
the
vice
will
versa.
is, my spouse in the will is not a beneficiary, she's still entitled?
The Marriage Act kicks in. And that's where
That's an interesting
you
dimension.
cannot, I cannot preclude Angelique from her 50% when we are married in community of property because I've stated it in the will. The Marriage Act takes precedence. So how we are married takes precedence.
Wow.
Yeah.
Wow, interesting. Thank you very much for joining us. It's a wrap. It's been an absolutely beautiful conversation. It was great being with you. Great stuff. Hayi kwanyalo ke sesifike emaphezelweni ehlelo lethu namhla. Ya, ngisangibonga ethi varsity ethu ngesikhathi sabo. Ngithaza bonga kanye nani ke babukeli ngekuba nathi kuze kube manje. Asihlangane futhi ngesikeli elitako lapho ke silethela ke lenye indzaba letawutsinza wena nemalungelo akho njengemthengi. From Miss Mphiwe Ngongwane and the rest of the team, sisinisale kahle. Do have a great week ahead. Cheers.
Aumela